All right. So having left off with the 6 stages of negotiation, we're now ready to talk about mediation, which in a lot of ways is very similar to negotiation but adds a huge benefit for us. So what is mediation? Well, it's basically a negotiation using a neutral, objective third party that still utilizes the 6 stages of negotiation that we have already talked about. So why use mediation? What are the benefits? What are the upsides? What are the downsides? Well, there's some very significant benefits. One of those being you can avoid extreme litigation costs. And if you're not familiar with litigation, you've probably heard a lot about litigation costs, but why are they so high? Well, they're high in pretty much any type of case that you're involved in, but you've got the bulk of your costs involved in discovery, and that's where cases, especially cases like products liability, personal injury, medical malpractice, any kind of case that involves expert witnesses, a lot of depositions, a lot of witnesses, you're going to very quickly incur a lot of costs that can be mitigated by going through the process of mediation. So avoiding extreme litigation costs. Now, what kind of costs are we talking about? Well, it's not uncommon to see expenses in cases running anywhere from $20,000, $30,000, $40,000. There are cases where it can run upwards of $100,000. Again, depending on whether you have experts that have to testify and travel. Experts, generally will charge by every hour that they're, traveling and going from point A to point B. So those add up quickly. So first, very significant benefit is helping to avoid extreme costs. The second benefit, and in some ways probably as important, if not more important, is the emotional toll that litigation takes on clients. Now, the problem is for attorneys that are accustomed to what we do day in and day out. As law students, you're already familiar with a lot of the process. Attorneys, we look at litigation, filing lawsuits, dealing with lawsuits day to day, basically the same way that we do if we go to the food store to buy a gallon of milk or some bread or go to the bank to cash a check. So the emotional toll that litigation takes on clients is enormous. And the problem with litigation is, and we talked about this several times, but at a minimum, if you file a lawsuit, you're going to be looking at least a year, and in many cases where there's any complexity to a case, even if there's not a lot of complexity, you can be talking about 2, 3, in some cases 4, 5 years from the time the case is filed until the time it actually goes to trial. And that's an enormous burden for your client. And again, you don't realize that because you're on the end where you're kind of working the mechanics of it. You are handling day-to-day activities with the case, and so you're always thinking about it from the strategic standpoint. But your client, and this is true whether it's a family law client, it's true if it's a business client, or really any client that's involved in litigation. Now, there are clients that you might represent that are very accustomed to litigation, but even clients that are involved in a lot of litigation sometimes can still take it very personally. So that's an aspect that you really have to consider as one of the biggest benefits to mediation, is helping to minimize the emotional toll. So, but why does it minimize it? Well, for a couple reasons. Number one, we're going to generally significantly reduce the amount of time that your client is dealing with this pending matter. So whatever the dispute is, the more quickly that we can resolve a matter, the better off your client is from an emotional standpoint. The other aspect of it is that the goal of mediation, by using a neutral or objective third party, is to work with both sides to come together and try to provide a creative, mutual solution to a problem that could never otherwise happen as a result of proceeding through litigation and to trial. So why is that? Well, hopefully you all know by now that there's only two ways that a trial can turn out in a case. You either win or you lose. There's no other alternatives. In mediation, however, you have an opportunity by hopefully having a very good, well-trained facilitator that works with the parties individually and together to arrive at a different kind of solution than you could get anywhere else. And so one of the things we talked about earlier is that obviously every case involves emotion, but say for example you have a matter involving harassment or discrimination. I can't tell you how often the person that files those types of claims is not necessarily interested in dollars and cents. Oftentimes what and this is true in just lots of cases generally, but one of the things that you hear that they want is an apology. And it would probably surprise you how often an apology is on our list of the 3 things that we want to look for in preparation stage, right? Which is determining the essentials for our client, what's important to our client, and what they desire. And so while you may think that the apology may be something they desire, in a lot of situations it's actually what the client, or what is essential or definitely most important to a client in a case. Now with a trial, you will never be able to have that kind of solution. Again, you win, you lose, that's it. But in a mediation with a solid, well-trained facilitator, you can come up with solutions that actually are more meaningful and more advantageous to your client if you're the plaintiff, and also beneficial to the other side, because if an apology is at the top of the 3 things, right, the essential or most important item that your client wants, that's probably going to result in a lower amount in terms of damages and dollars that the defendant is going to have to pay. So you can actually have a win-win. You know, we spent a lot of time talking about that pie, and you can only cut up a pie so many ways. But with mediation, you can, through identifying things like what is really at the root of the dispute, you can figure out ways to allow one side or the other, or both hopefully, to increase the amount of the pie that they perceive that they're obtaining through the process of mediation. You know, mediation, like negotiation, is a process. And I emphasize the word process because it's so critical to understand that you know, when you do something a lot, sometimes you lose focus on what's most important. We talked about doctors having frequent malpractice lawsuits because they cut on the wrong arm or the wrong leg, just the wrong body part. And that's because we tend to forget the fundamentals of most things. They say what separates professional athletes and gold medal winners from amateurs is that the professional athletes have mastered the basics. And that's the thing that I keep emphasizing over and over, is that you don't want to lose sight of the fact that mediation, like negotiation, is a process that you have to pay very close attention to and consider throughout the entirety of it, in all aspects, not only the 6 stages that you're going to work with, but in selecting a mediator and going through the process and understanding the value of it. So again, in talking about benefits, we're going to save our clients probably very significant money. We're going to help minimize the emotional toll on the client. And in another example that is crucial is family law cases, right? Where there's custody disputes and there's kids involved. And that's why you see in almost every venue in the country mandatory mediation in family cases and divorce cases involving custody, because when a divorce case is protracted and it lingers on and on and on, that has no benefit to the kids. There's no value to that. So, I think everyone has realized after a lot of years that mediation is an invaluable resource, especially in family law, to help reduce the amount of stress that's placed on the kids, who are always, no matter how awesome the parents may be, are always stuck in the middle. So we're definitely going to reduce the emotional toll for our clients. That's definitely a pretty crucial element as far as benefits. And then controlling how the dispute is ultimately resolved. And that's part of what we talked about earlier, about the ability to creatively resolve through this facilitator that is neutral, that is not in any way for one side or the other, that works to bring the parties together no matter how disengaged they may be, no matter how hostile they may be, but works to facilitate a creative solution where there's some, maybe hopefully some thinking outside the box and seeking out and understanding those elements that we talked about a long time ago, what's essential, important, and desirous. So understanding those things can provide a solution for each side that is far more beneficial than what can ever be accomplished going through litigation and going to trial. So those are the benefits for using mediation. And again, that's why you see it as a mandatory process in family law, and also actually in more and more venues, and even in federal court, you have mandatory settlement conferences, which are essentially the same thing. So what are the downsides to the process of mediation? Well, number one, it can be a waste of time and money. If either side, or in some cases both sides, have the sense that they've been compelled to engage in this process, that's going to be a problem. And it's a problem because if there's an element of compulsion in the process of mediation, it's essentially anathema to what we've been talking about, right? Mediation is the cooperative effort between two parties that are willing to sit down together and work out a reasonable solution to a problem. Now, what's difficult to explain to a client, and this really goes back to the very beginning when we talked about the need to spend the time and effort on the preparation stage with your client to thoroughly explain the process, not only of the litigation process, but especially of why things like mediation are so important to your client, and how it really benefits your client emotionally, financially, in every way. So obviously when there's a dispute, there's going to be hostility that's underlying it, and generally it's going to be on both sides of the fence. So in almost every venue, as we've been talking about, there is some type of mandatory mediation process, and that's true in federal court and state court and in many other venues, administrative type venues and so forth. What's important to explain to the client is that although the process may be compulsory and mandatory, there is nothing compulsory about the need to actually resolve the problem, right? I mean, you could ostensibly sit down at a table with a mediator and basically within the hour say, well, I'm done, I'm not interested in proceeding, let's just shut this down, I don't care, I want to go through to the end, I want to go through trial, and you know what, that's fine. It may not, obviously isn't really operating in good faith, but if that's the way one side or the other feels, then it really truly would be a waste of time and money to proceed through the litigation process. The key is both with you as the counselor and attorney, and the other side of it is the training and expertise of the mediator. And I'm going to talk about this in a little bit about selecting a mediator, but this is why it's so absolutely vital that you pick a mediator, not because a mediator is someone that you're friends with, have beers with, know through someone else that's a good guy or gal, but someone that you absolutely know is committed to the process of the mediation, because it's the process that's going to create the success and the motivation and the persuasion for each side to recognize the value of putting aside hostility and anger and all this emotional baggage to keep moving forward towards a successful conclusion. Because taking that hostility and that anger, really, when you think about it, it has no value to anyone, because one of those sides is going to lose if they go to trial, and that's a given. So what value is there? And if, really, whether you have a bench trial or a jury trial, it's pretty hard to really, with any certainty, identify the true odds of your success. So why take that risk when there's an opportunity to work together to come up with a resolution? If people can put emotion aside, and remember we talked about this is all psychological based. Litigation is psychological based. The vast majority of everything that occurs through the process of litigation, in terms of with your client and in their minds, it's psychological. And that's why you have to divest yourself of that emotion in terms of how you work through and strategize through a case. But if one side or the other is truly recalcitrant and absolutely refuses, for whatever reason, to proceed or to, in good faith, work with the other side to arrive at a resolution that makes sense, then it really is a waste of time, and that would certainly be a downside to the process. Now, another problem with mediation is the idea that if I go to mediation, especially early in a case, then there's a tendency where I'm going to put my cards on the table, and I'm essentially going to make my case to the other side. Now, most attorneys strategically don't want to do that, right? It is like a card game in a lot of ways. You may have an ace in the hole, but you want to keep it to yourself. You don't want to let anybody else know that you have this ace or a smoking gun. But when you go to mediation, if you're operating in good faith, really you almost have to put at least most of your cards on the table to have any opportunity to make it work. So that is a concern frequently by attorneys, of course, that they don't want to disclose what they have to the other side. But in reality, that may be a bit of a specious argument, because the fact is that through the process of discovery, there really aren't going to be any smoking guns at the conclusion of a case. Through discovery, you're going to find out everything that the other side knows and has, and vice versa. So while initially you may not have all the information, or your opponent may not have all your information, ultimately when the thing comes to an end, both sides are going to know what the other side's case is about and how they're going to proceed on it. So that argument really doesn't hold a whole lot of water, although it depends on at what point you are in the process. And that again boils down to strategy. And a third, and we kind of talked about it already, but a third downside to the process can be the feeling by one or both parties that there's an imposition or a compulsion to settle the claim. Now, as I said, where there is a compulsion frequently is through the court or administrative agency mandating a settlement conference and that you sit down and go through this process. But there's never a compulsion. It's your client's right, absolute right, to be able to move forward to a trial if that's the venue that you're in, a bench trial, jury trial, or a hearing if it's an administrative scenario. But it's your client's absolute right to do that if that's what they want to do. So it's important that you, at the very front end through the preparation stage, explain to your client that while the process may be considered compulsory and mandatory by the venue that you're working in, the ultimate end goal is certainly not compulsory of settling or resolving the case, not at all. So if the client truly understands that, it's going to go a long way in helping a recalcitrant client to realize that it's okay to try to negotiate in good faith and work with, especially when you have a neutral and objective third party involved. So, and the other thing that you hope is that your mediator is acutely aware of the concerns that clients have about the compulsion aspect, and that they are able to address those concerns in a way that's meaningful. And frankly, what you'll see a lot of times is you're going to hear a mediator say the exact same things that you had said to your client, probably many times, but all of a sudden, because another person says it, it must be true. And that person's an expert, and there you go. So those are the pros and the cons of mediation. I think overall, when you consider the weight of everything, your upsides are certainly far outweigh any downsides to the process. Just no question about that. So why not just negotiate? I mean, if we're using essentially the same stages, and for all practical purposes we're doing and talking about the same thing, why? Well, we know that many clients, many people, well, most people do not like attorneys. And oftentimes you'll find that your clients aren't necessarily big fans, especially if you haven't really spent the time necessary to make them comfortable and truly understand the process that they're going to be going through, and actively listening to what their situation is, conveying it back in a way that they believe and know that you genuinely do and have absorbed that information. They could become recalcitrant fairly easily and quickly in terms of acquiescing to the strategies that you're proposing. And it's easy to, as an attorney, to if you have a client that says, I don't care what you say about mediation, I don't want to spend the money, I don't want to spend the time, I just want to go through a negotiation. If that doesn't work, we'll just go through to trial. And so, it would be easy to just simply say, hey, I'm going to write up a quick letter to my client. I'm going to repeat what he or she said. I understand that you understand the process of mediation. You're not interested. You simply want to go to negotiation path, and if that doesn't work, go to trial. But that's the easy, lazy approach, and that really isn't going to, in the end, resolve anything. It may make you feel better because you know that you're going to do less work ultimately, but really, why? You know that the strategy that you've proposed, that you've spent a lot of time and effort on, is the right strategy for your client. And that's why you went to law school, and that's why you're being paid, whether it's hourly or on a contingency fee, to arrive at this strategy, to use careful preparation and intentionality to get the best possible outcome for your client. So you don't want to lie down and just acquiesce to a client that says, I'm not interested. If it's your strategy, I mean, attorneys are generally in control of strategy. You need to think about whether there's something that you didn't do properly in terms of your explanation to the client of the process, and really genuinely making the client feel comfortable and provided them with enough information in lay terms that allowed them to understand what is really happening and why your proposal and your strategy recommendations make far more sense than what they want to do. But so why not just negotiate? Because when you have a recalcitrant client, it can make an amazing difference to simply add that third neutral party into the process. It's kind of like if you have a spouse or significant other that you have suggested that they do something that would be helpful to them. Let's take some just ridiculous example, but you know, they have some issue with their car perhaps, and you know, you have some experience with mechanics and you understand how cars work, so you make a recommendation, you've researched some things, and you are pretty comfortable that what you're recommending is going to work. And the spouse just kind of bucks what you're saying, and then ultimately goes to the mechanic down the street, pays $500, and that mechanic tells them the exact same thing, and you could have done the job for $45, but again, there's a professional there, right? And so then the spouse or significant other feels better, like, well, now I know it's right. So sometimes that can be the same result when you add a third party, and again, it has to be a highly trained, process-oriented mediator that truly understands the concept of facilitation, so that the parties can really come together in a meaningful way in good faith. So that's why negotiation's a phenomenal tool, and it's also very excellent if you know your opponent and you have an ability to understand his or her strengths and weaknesses and can use that to your advantage. Well then, you know, negotiation certainly may be more advantageous. But oftentimes, you know, if you hit a bump in the road or a bottleneck in terms of where your case is going, mediation can very frequently free up that bottleneck and resolve problems much more expediently, and again, create a much better outcome for your client. Because remember that the longer litigation proceeds and goes on and drags on, no matter what kind of litigation you're in, the more expense and the more damage occurs to your client. And when I say damage, I mean financially and emotionally, because it takes its toll no matter what kind of client you have. I don't care if you have a 60-year-old client that's been involved in 50 lawsuits, but this is a case against his or her business where, you know, they have a claim of discrimination, and you know, but that defendant, your client, if you're on the defense side, takes it personally because they don't believe that there ever was discrimination, and they may genuinely believe that, and there may not be any discrimination. So, you know, again, that's going to take a toll both emotionally, from a time standpoint, and from dollars. So those are the things that you want to think about at all times as you're working through these processes and considering what's best and when it's best to go forward. So that's a kind of a good segue to the question of, when do we use mediation? Is it best to just wait till the day before trial, or the weekend before trial, on the courthouse steps? It's certainly done, and that's not uncommon. But mediation has a benefit of being very flexible in terms of the best time to use it. So, for example, there are times when it makes sense to encourage mediation before you even file a lawsuit. And as an example, I had a client recently that received a letter from an attorney that a class action lawsuit was going to be filed based on violation of a wage statute, a federal wage statute, the Fair Labor Standards Act, right, FLSA. And so the letter went into detail about how that attorney represented a former employee, and that employee believed that that the FLSA had been violated, and so they wanted to engage in discovery, file the class action, blah, blah, blah. So the client recognized that this was not a, just some kook that was going to make a ludicrous threat that they were going to never follow up on. Instead, they researched the attorney and recognized that this law firm had filed many class action lawsuits and actually had obtained very significant settlements and awards through the process of class actions. One of the problems with class actions is the enormous amount of discovery that's involved and the extreme expense and time consumption in the process. So rather than go through that, the company decided that they would entertain discussions with the law firm prior to the lawsuit, and that was done, and ultimately it was resolved for a very small sum through that process before anything was ever filed. Now that was really a win-win for both sides, and so sometimes there are definitely opportunities to mediate a case before it ever gets to the actual filing of a claim. Now then there's an opportunity to consider it before discovery begins. Now that's probably going to be more rare than anything, because if you don't have any evidence to support a claim that's being made by your client, I don't know how you would ever be able to really proceed meaningfully through a process like mediation, because what would you say in order to support your demand for X, Y, and Z? Now there are times that your client may have a smoking gun in his or her possession and brings something to you, an email, a letter, whatever, that is irrefutable, and that may be an opportunity for you to say, well, look, we can go through this lengthy process of discovery, but in the end, I think that all that's going to do is validate what we already know from the defendant's own written documents and admissions. So at a time like that, unless you have reason to think that there's something else hiding under the leaves and the weeds, then that could be a very opportune time to consider mediation before actually proceeding with discovery. And as a plaintiff, that can be true because defendants recognize the value of resolving cases before discovery is initiated, and so a lot of times defendants are willing to pay a premium in that type of scenario. So see, that's the value of understanding where you are in the case and look at it strategically, and that's why there's no such thing as a cookie cutter boilerplate strategic approach to cases, because every single one of them is different. Even if all you do is family law, even if all you do is patent work, all you do are business transactions, every single one is going to be different in some unique way. And so you can't look at cases like they're cookie cutters. You have to look at them for what they are and what opportunities you may have and when those opportunities should best present themselves. Because timing, you've heard, is everything, and that is often true in ADR processes like mediation. So if you have a smoking gun or some evidence that supports the basis, the underlying basis for your claim, that certainly can be an opportunity and a time to go forward before the discovery starts. You can also do it after the initial phase of discovery, when you've done your more perfunctory aspects like interrogatories, request to produce, request to admit, and you have information that may support what you believed was true, but now you have more documentation to support it. While you may not have everything and you may not have expert witnesses to say that, yes, based on my review of X, Y, and Z, my opinion to a reasonable degree of engineering certainty is this. While you may not have that, you think and know that you have enough to be able to make a convincing argument to the other side that in order to save valuable time and money, it's a good time to consider mediation and see if you can work through some of the disputes. So we can look at mediation before a lawsuit's ever filed. We can look at pre-discovery mediation, after the initial phase of discovery, also after basically most of our discovery is concluded, but maybe before disclosing experts. And again, the experts oftentimes is where you really take the hit on the high dollars involving discovery. So that's another time that you might consider it. Again, if all of your opinions, expert reports are in your favor, this may be a time to consider that. Also, after that point, you can consider at the closing of discovery when it's concluded, which is probably going to be very close to the time that your trial is going to begin. But if you have waited to that point, that's going to be a problem. And the reason it's going to be a problem is because your client, most likely, if you are not mediating your case until the eve of trial or very close to the time of trial, you probably haven't done a very good job of speaking with your client and explaining what their expectations should be based on the information that you have and what you know about the law and the way your venue works that you're working within. If they have not heard and if they have not understood those expectations up until this point, which is probably 1, 2, 3 years after the claim was filed, they're going to be very surprised if you come back and say, well, I know initially we talked in vague terms. We talked about maybe your case was worth $250,000 and, our fee is a third and the expenses would probably be $20,000, $30,000. And now after all the discovery's concluded, you really haven't maintained discussions with your client about where things are in terms of the costs for discovery and experts. So now you come back to your client on the eve of trial or close to it and say, hey, we have an offer to settle the case for $80,000 or $100,000. Then come to find out that your hard expenses are $50,000, and that doesn't even take into account the attorney's fee. By the end, and all is said and done, your client may walk away with nothing. Actually, in some cases, it may walk away where the client owes money, right? I mean, that's not the situation that you want to be involved in, where you are having to tell a client that after all has been said and done and all of the discovery has been obtained and reviewed, the expert opinions have come into play, and now your evaluation has been reduced from $250,000 to $100,000. That is going to be a kick in the face to your client, and it's going to be hard to walk away from that without being seriously damaged. So that is definitely something to consider, again, in not only the very initial preparation stage, right, where we're really sitting down and spending some very substantive time with the client, understanding what's happening, where they're coming from, but also continuing to discuss with them, you know, where we are in the process and how your initial evaluation may have fluctuated, and more importantly, why, right? I mean, it's one thing to say, well, I think the value of the case has now dropped from $250,000 to $200,000. That can be less damaging to the client and less problematic if you follow that up with, now here's the reasons why I think that the value has dropped. If you can explain that in an articulate way, then your client is certainly going to be less angry and concerned about you. So those are the times that you can consider mediation. And you know, again, mediation is not a static process. It's a very dynamic and very flexible process in the ADR umbrella. So it's something that you may use on multiple occasions. You may do it twice, you may do it once, you may do it 4 times. There may be reasons that through the pendency of litigation that things arise that are fairly significant, and those times appear to you to be opportune to strike while the iron is hot. And so while that may be expensive, and it will be, because mediators are not cheap, but it may be a situation where you use mediation on multiple occasions, and that's fine because it is a flexible process, it's dynamic. It also gives you an opportunity to consider the value of your facilitator or mediator. And if your mediator has been someone that hasn't particularly met your expectations, then that's a good time to consider moving to a different type of mediator. So it gives you a chance to make some changes if the process hasn't gone as well as you had hoped it would. All right. That brings us to the process of selection of a mediator and also mediator styles, which both those things are extremely important, and we're going to go into here in just a second.